Hello, IP friends. Welcome to #IP series with your favorite podcast hosts, Rita, and we're reaching the. If you're a first-time listener, you're welcome, and I hope you find my podcast interesting. I hope you learned something, and also don't forget to subscribe and favorite my podcast on any other streaming platform you're currently listening on, so you don't miss out on any other juicy episode. For my returning listeners, I just want to say I love you guys. I appreciate you guys for always coming back to listen to my episodes. Don't forget to also share your best episodes with your friends and contact. So, what do we do here? Basically, #IP series is a podcast that features conversations about recent trends and development on copyright, trademark, patent, industrial design, trade secrets, geographical indication, and plant variety. Sometimes I get tagged on trendy IP cases. Sometimes I get questions in my email, which is ipseriesinfo@gmail.com. So if you have any case you want me to talk about, if you'd like to be a guest on my podcast, just send me an email and I will reach out to you. And so I welcome you to today's episode. So, like I've always stated, IP interplays with every sector, and today's episode I will be talking to the graphic designers, the illustrators, the portrait makers. If you're a creative, basically this episode is for you. However, if you're not in the creative industry, you can also listen and learn one or two things. So I got tagged on this story, which I found to be very amazing. So a Nigerian American Nigerian got his work reproduced and copied all the way in Nairobi. And he came on Twitter and started talking about it, how the mall called the Imara Mall, so Imara is spelled Imara in Nairobi, got someone to do an artwork, and it was his own artwork, his design, that were reproduced on the mall, the wall of the mall. And it got me thinking, how do creatives resolve disputes that take place in another jurisdiction? So cross-border dispute is what we call them, while interstate disputes are more or less like trans-border dispute. So I'm just going to delve into it and share my views. This is not legal advice, guys. I just like to analyze cases and just shed lights on what creatives and innovators and brands and SMEs and entrepreneurs and business owners should really know about intellectual property. I mean, it's a very interesting pathway. I always find each cases I come in contact with interesting and insightful. It also gives me takes me on a journey where I have to learn certain things. So I hope you guys learn learn from this episode rather. So let's get into the story. So our case study is Temi Coker against the Imara Mall. I already spelled Imara initially. So this design which Temi Coker is talking about, he calls it the Behance Project, which is spelled BEHANCE. And in a series of tweets that he made, he said he was going to reach out to his lawyers, or he was ready to talk with his lawyer, but he felt like he can't be following up on protecting his intellectual property in different jurisdictions. So this episode will shed light on how you can protect your work, because IP is territorial in nature, and it's only the territories or countries or jurisdictions that you register your work that you get to enjoy protection and legal backing. Also, while I went through the comments under his post, I saw that a lot of people were not really aware on how intellectual property works, especially as it relates to copyright. Copyright basically grants you automatic protection from the moment you create your work. So his designs, the Behance Project, already has automatic protection. However, for several reasons, which I will state later on in the episode, it's very important that you register or protect your copyrighted work as provided for in the laws of the country. So, for instance, in Nigeria, we do a voluntary depository services where you have to deposit a copy with the Nigerian Copyright Commission. But yeah, let's get into the nitty-gritty. So because this case features a Nigerian and also a Kenyan, I will be, going back and forth on the Nigerian copyright law and the Kenyan copyright law. Now, are graphic designs, portrait, illustration, and other artistic works eligible for copyright protection in Nigeria and Kenya? The answer is yes. I mean, going through the laws, they both had similar provisions, as it relates to copyright protection, infringements, and the rest of it. So I'm just going to highlight a few sections. So to answer your question, because IP is territorial in nature, Section 1 of the Nigerian Copyright Act already provides lists works that are eligible for copyright protection, while Section 22 of the Kenya Copyright Act lists works that are eligible for copyright protection. However, subsection 4, which is similar to our Nigerian Section 1 sub 4, provides that a work shall not be eligible for protection if the reason for the work being created is to do any act related to the work that will involve an infringement in some other work. So if you just created the work because you were trying to infringe on another person's work, then you don't have legal backing or copyright in that work. So who is an author in this case? Now, an author would be a person who, by the arrangement necessary for the creation of the work, was done while Section 51 of Nigerian Copyright provides that an author in the case of an artistic work is the creator of the work, which in this case is Temi. Also, Section 10 provides that the initial person who creates the work shall be the author. So authorship shall vest in the initial person that created the work in this case, and that in this case is clearly Temi, unless the other artist, comes out to say, "Oh, I am the original author. This is how I got inspiration." But Temi has already put out pictures on, his project. So he did share a link on his Twitter page while making this thread. So yeah, let's just go back to the law. So I'm reading verbatim. Some place I'm going to paraphrase, but I'm reading verbatim from the laws, so we are well informed on what the law provides. Ignorance is not an excuse, guys. Okay, so still focusing on the Nigerian copyright law, it says an artistic work under this same section could be a painting. So if you like to paint, your painting already enjoys protection in Nigeria. If you like to draw, if you have etchings, if you have lithographs, woodcuts, engravings, prints, map, plans, diagrams, work of sculptures. I love sculptures, guys. Photographs not comprised in a cinematograph film. Works of architecture in the form of a building models. So if you're an architect, take notes. Works of artistic craftsmanship, and also subject to subsection 3 of section 1 of this act, pictorial woven tissues and articles of applied handicraft and industrial art. So if you're reading fine arts in university, trust me, guys, you already enjoy IP protection. However, that's a different ballgame, because if your school has an IP policy that states that whatever work or artistic work done while you're a student belongs to the school, then you can't really fight it. But the law provides that you are the original author, which is subject to some exceptions as the case may be. So how can you as an artist protect your work in Nigeria or in Kenya? So I already stated that copyright grants you automatic protection so far as the work is in a fixed, medium, or tangible form. Both Nigeria and Kenya advise copyright owners to deposit a copy of their work through their e-registration system. So for Nigeria is the Nigerian copyright e-registration system, while Kenya has its own e-system for registering their work using the National Right Registry under the Kenya Copyright Board. So check that out. They have online registrations where you have to upload your work virtually. You make payments online and also get to print your certificate, which is similar to what we do here in Nigeria. Which is what we do here in Nigeria as well. So can copyrighted work be protected internationally? This is I think this is one of the areas that creatives find a bit confusing. So I'm going to take my time to actually explain this. Can copyrighted work be protected internationally? The answer is no, because of the territorial nature of intellectual property. However, based on some international treaties and copyright laws, countries like Nigeria and Kenya can extend copyright protection for literary and artistic work. For instance, you have the Berne Convention, which offers protection for literary and artistic work. You have the WIPO Copyright Treaty. You guys, please check them out, which is an agreement where members grant members. So if Nigeria is signatory to that and Kenya is signatory to that, you have some level of IP protection or copyright protection is extended to you as a member state. Then you have the TRIPS agreement, which is the trade agreement on trade-related aspect of intellectual property, which gives the minimum standards that allows member states to extend extensive protection of IP. So you have like the most favored nation clause, and the umbrella clause, and etc. So now we are doing international trade. Fine. Right. So how can an artist explore a multi-layered IP protection for their graphic design? So most times you find out that creators are just focused on one type of IP. So because I'm an artist, I'm just going to ask Anwari questions about copyright and no other type of IP. But then your name, your brand name, if you have a logo, because that's the thing, you're building a brand for yourself, an identity for yourself, especially in this digital era where digital footprints are very important for data collections and valuation, the rest of it. Your brand name, your logo, your sign symbol affiliated with you can be trademarked. Trademark is also a type of IP. So other than relying on copyright, you can also rely on trademark. Then you have design rights. So I'm speaking specifically now to designers or graphic designers and illustrators and painters. Not the list of artistic work that I initially mentioned. Yeah. So if your work fall within that category, those are designs that are considered to be new. So it could be a combination of lines or colors or both, or any three-dimensional form, whether or not they're associated with colors. So if you look at the Temi Coker's picture, you see that it has a combination of I think this is mint, there's mustard, there's red, there's turquoise blue, there's black, there's yellow, there's green. So there's a lot of color combinations and lines, 3 dimensions, and the rest of it. So that gives you an edge at the end of the day. So you have 3 different types of IP that you can protect yourself in. And, like I earlier said, the laws of the country you wish to protect yourself will guide you as to what to do. Trademark and design rights requires that you actually do a proper registration. Whereas for copyright, just other than the voluntary registration, you already enjoy legal backing. So when we tell clients this, the first thing so I don't necessarily need to register my work. Not really. So yes and no, you don't need to, but you have to for documentation purposes, to save yourself from costly litigation dispute, to be able to have evidence of ownership. You can also use it for countries that have collaterals, that allow IP as collaterals. You can use your IP as a collateral. It helps when they are auditing your intellectual property. It helps you
commercialize your work through licensing assignments or selling of your work. So it makes it easy when you're selling. So you already have so for collecting society, you're doing an assignment, giving the collecting society the authorization to help you monetize your work, get your royalties, etc. Same thing with anyone that you give permission to actually use your work. So as a graphic designer, an illustrator, a painter, a sculpture maker, a portrait maker, an artist, basically, what are the rights that you are entitled to because you own this copyright? One, you have the right to publish the work. So Temi, as the designer, he had the right to publish the work to the public. So I've created the Behance Project. Here's my project. He puts it on social media platform, puts it on the website. He enlarges and decides to sell it. Can use it to do anything he wants to do because he is the only one authorized and has the exclusive right and is entitled to actually publish it to the public. Then he also has the right to distribute, so you can distribute it to different platforms, to different people. Now you get the work. Do as you please, basically. That's what exclusive right gives you as an author. You have the right to also adapt the work, so you might decide to do some sort of animation, a play, anything. You can decide to translate it into different languages, anything you want to. You can also commercialize it through licensing agreement, so you can license your designs to, say, a film, a producer, an art gallery. So for instance, I think the proper thing that the Imara Mall should have done was to reach out to Temi, get into a licensing agreement, and give them the authorization to actually reproduce and publish that design, the Behance Project design, on the mall. Hard. What's so hard in asking, hi, can I, we love your work, can we? Well, I guess that comes with being in the digital area where people just it's not here, let's take and use, carry and put for your own claimer. But yeah, we move. Sorry guys. So next line of conversation is, how does copyright protect foreign works in Nigeria and Kenya? Now this depends on the laws of the country. In Nigeria, Section 2, Sub 1, Paragraph A provides that an individual who is a citizen or who is domiciled in Nigeria or who is a body corporate registered in Nigeria under the laws of Nigeria can enjoy copyright protection. Section 3 goes further to say that a copyright owner can enjoy protection by reference of a country if it was first published in Nigeria. So if you open books, most times you see published in Nigeria or in a country or any other country, while Section 5 makes provision by reference to international agreement as previously listed. However, I want to draw our attention to Section 51, which says that where any country is a party to a treaty or international agreement to which Nigeria is also a party to, the minister, who is also charged with the responsibility for culture, is satisfied that the country in question provides for the protection of copyright in works which are protected under the Nigerian Copyright Act. So if the minister is going to grant you some sort of give your work some sort of protection, the minister may, by order in the Federal Gazette, extend the application of this act in respect of any or all of the works referred to in this subsection. So basically, the minister is the one that has the authority to actually extend the protection as a member state by making a publication in the Federal Gazette and stating that this person, who is an individual or a body corporate based in Nigeria, he's hereby granted a copyright in his work. So these are the things that you need to find out about. So both Nigeria and Kenya copyright law actually protect foreign work. So for the Kenya version, please check out section 24 to 25 of the Kenya Copyright Act. Let's go through section 24 and 25. So in 24, it talks about copyright by reference to country of origin, which is similar to the Nigerian law. So it says copyright shall be conferred by the section on every work other than a broadcast which is eligible for copyright, which being a literary, musical, or artistic work, or any audiovisual work is first published in Kenya. Being a sound recording is made or first published in Kenya. Being a broadcast is transmitted from transmitters situated in Kenya. Copyright conferred on the work, this is subsection 2 now. So copyright conferred on the work by this section shall have the same duration as is provided in section 23. So term of duration for literary, musical, and artistic work in Kenya is 50 years after the end of the year in which the author dies. Now section 25 talks about copyright in works of government and international bodies. So subsection 1 provides that copyright is conferred under this section on any work eligible for copyright which has been created pursuant to a commission from the government or such international body or non-governmental body as may be prescribed, and which no copyright has been conferred under section 23 sub 1 and 24 sub 1. Subsection 2 says copyright conferred by this section or a literary, musical, artistic work shall subsist until the end of the expiration of 50 years from the end of the year. So yeah, I'll just stop here and you guys just do the rest of the reading. But you shall get the point that both laws are similar and grants you certain or similar protection for your copyrighted work. So what rights does Temi Coker enjoy as an artist? What rights does Temi Coker enjoy as an artist? First, you have the economic right to earn and make money, generate revenue from your creation. In this case, I don't think that was done. Since the artist contracted by the Imara Mall did not reach out to him specifically, he didn't even get a letter of intention or anyone saying, yo, we like your design, we'd like to, reproduce it on our mall. And, the mall actually made a post. So they made a post about it on Instagram dated February 16th. I don't know if it's still there, but as at the last time I checked, it was still on their Instagram page. So it's just the Imara Mall. It says, welcome to the Imara family, February 16th. Read section 6 sub 1 paragraph B of the Copyright Act and section 26 sub 1 paragraph A to K of the Kenya Copyright Act to see the list of acts not included in as exclusive rights of an artist to control his design. So for instance, if it was just for private, so the design, maybe let's say you downloaded it online, just use it on your phone as screen saver, or just for yourself viewing pleasure, or you're criticizing it, or you're doing a review, or you're researching about it, no one. But the fact that you actually got paid after reproducing someone's work, that will not fall under fair dealing, sincerely, and that's bad. So we need to learn how to respect people's efforts and creativity. Secondly, you have the moral right to object to any modification or derogatory act done to your work while trying to protect your reputation and integrity. So you can see section 12 sub 1 of Nigerian Copyright Act paragraph B and section 32. Now, moral rights are non-transferable, but you've seen clauses where someone is like, you're transferring both your economic and moral right. And I read one 2 months ago where, anyway, this is related to a musical artist, where he was told that he was transferring his moral rights in perpetuity, and I had to tell him, you can't sign that. I mean, at least your economic right can be transferred, but not your moral right, because you need to have a say as to how someone intends to use your work, whether it's your music, your videos, so it doesn't bring bad reputation to you, especially in this era where cancel culture is like everyone's always quick to cancel someone for something. So then you have the performance rights and the rights of producers of sound recording. Though not relevant to this game, but I just wanted to point it out there that these are the rights that creatives enjoy from their work. Copyright registration in Nigeria and Kenya are voluntary, and failure to register your work does not deny you of any of these exclusive rights of being an IP owner. So whether you register your copyright or not, it does not deny you from your economic rights, your moral rights, or your performance right. Nah, it doesn't. So I just wanted to point out, if you're in Kenya, please follow the Kenya copyright board. They post a lot of content and they do a lot of awareness and education. I think I'm also subscribed to their blog and newsletter. They do a lot of publication. So if you're in Kenya or in Nairobi, you want to be in the know as to how to protect your copyright, please follow the Kenya copyright board. This is not paid advert, guys. We're Africans, just have to do the needful, and with the African Free Continental Trade Agreement coming in, we just have to put ourselves out there so we don't have cases of people trying to take advantage of us. Same thing with the Nigerian Copyright Commission. They're doing the best they can, organizing an event. I know this year they had an event for DJs. Then we had the public hearing last year, and I'm aware that the copyright bill it's on its way to being passed. So if you're in these countries, take note, guys. So what is the importance of registering your copyright? Remember I said I was going to tell you guys why you really need to register your copyright. So in the US, thanks to the Gigi Hadid photographic case, the requirement now for suing for infringement is that you must have registered that photograph the copyright office in the US. So let's bring it back home. What is the importance of doing a copyright registration? One, it acts as evidence of ownership. The documentation, the copyright certificate that you get acts as. So the documentation acts as evidence of ownership. It also makes it easy for you to be able to commercialize your work. Also help the author avoid costly disputes over ownership. You're entitled to statutory damages, and you also have the right to sue for damages against unauthorized use. So Temi, you have the right to actually sue the Imara Mall for infringement, for copyright infringement and unauthorized use of your Behance project. So I'm going to explain something towards the end of this recording, but let's keep it moving. Now, I did a poll. Sadly, just 2 people voted. Why, guys? Please engage my content. I'm begging. Now, I said, have you done a copyright registration in Nigeria or Kenya? 50%. One person said yes, Nigeria. The other person said not done at all. No response from Kenyans. I'm sad. Really, really sad. But then, what do you do when your work has been infringed and used without your consent, permission, and authorization? 1, be certain that your copyright was infringed. So Temi now has gone to show. He's certain now that the Imara Mall had reproduced his work and copied it without his consent. So he's certain now that his copyright has been infringed. He has also identified the Imara Mall as an infringer. Last I checked, he said he was going to speak to his lawyer. But in this instance, I would advise you guys to talk to your intellectual property lawyer or your copyright lawyer. I'm also an intellectual property lawyer. I'm an intellectual property lawyer, please, based in Nigeria. In Nigeria, the Federal High Court has jurisdiction to hear all intellectual property related dispute, whereas in Kenya, the Magistrate Court or the High Court has jurisdiction over copyright matters. See section 15 to 16 of the Nigerian Copyright Act to find out more about infringements. You're also entitled to an account of profit if the defendant claims to not be been aware and had no reasonable ground for suspecting that the work enjoys copyright protection. And this is a bit dicey. So can Imara Mona come and say, we're not aware that this design belongs to Temi, we thought this was an original work? That's what the law provides. So that's section 16 sub 4 and also Section 35, Sub 1, Paragraph 4 to 5 of the Kenya Copyright Act. Now I'm going to talk about something else. So, offenses by a body corporate such as the Imara Mall. So when the offense is committed by a corporate body like the Imara Mall, the corporate body and every person who at that time that the offense or the infringement was committed was in charge of or was responsible to the body corporate for the conduct of the business to the body corporate, they shall be deemed to be guilty and such offense and liable to be proceeded against and punished accordingly. So basically, if you worked or you worked on the projects, the Imara Mall Behance Project, you will be held liable and be punished accordingly. However, if you prove that the offense or the infringement committed was done without your knowledge, or that you exercise all due diligence, IP due diligence is very important, guys. So it helps you determine the chain of title, who owns the work, is it an original content? And that's the conversation I have with my clients most times. Are you sure that the content you're bringing to me is original? If it's not, let's get papers signed, get the necessary consent from the owner, so that we avoid Twitter threads and being in front of a judge at the end of the day. Now, subsection 2 also provides that when an offense under this act has been committed by a body corporate and it is proved that the offense was committed with the consent of any of the director, manager, secretary, or any officer of the body corporate, such director or such person shall be deemed to be guilty of that offense and they shall be liable to be prosecuted and punished accordingly. So again, I did another question here. Do you think that Imara Mall was aware that the design belonged to Temi Coker, and do you think they deserve to be punished? 3 votes said yes. Because I need more votes, guys. Help me. I like my conversations being very interactive. So in Kenya, Section 38, Section 5 provides that a penalty of 100,000 shillings will be given to the body corporate or an imprisonment not exceeding 2 years. So as an IP owner, you can also commence civil and criminal suit against an infringer. To find out more about it, please speak to your intellectual property lawyer to be guided on what to do. So you're guided on whether it's a civil case or a criminal case. But if you want me to do to answer that question for you, send me an email or just tag me, and I'll do my best to answer. Now, do you need to obtain consent, permission, authorization before using a copyrighted work or any intellectual property, whether it's patent, design, trade secret, geographic indication, plant variety? We have a plant variety act in Nigeria. The geographic indication bill is still ongoing. So trademark, patent, design, yeah. So the answer to that is hell yeah, you do. And from the looks of it, I don't think the Imara Mall actually got permission from Temi, which is why Temi had to come to Twitter and make that post. Now, in wrapping up, guys, wrapping up. So, in wrapping up, the Imara's Mall use of Temi Coker's Behance Project design will not pass as fair dealing. I already said that previously. Fair dealing, it's like you're using the work without the intentions of wanting to make money from it, and clearly the Imara Mall had ulterior motive, so the fair dealing argument will not fly in this circumstance. And he was never even acknowledged. I mean, even if you're using it for commercial purpose and you just say this Temi Coker, credit Temi Coker, that works. But the proper thing is to reach out to the person, pay them their royalties, use the work, and also acknowledge them at the end of the day. Also, the fact that it is assumed that the artist that was hired to do this project it was a work for hire arrangement, meaning that the rights to the artistic work now belong to the company. So the question now will be, who will be held liable for the unauthorized use of the design? Is it the artist who did the reproduce and copy the Behance Project design, or the Imara who is a body corporate? Now, both parties, for me, I would say both parties, because I'm going to sue the artist, and I'm also going to sue the company for not doing their due diligence and verifying that the designer artwork was his original design, not an inspiration or a copycat of another artist's creative work. See what I mean? So I did a poll again, though. Luckily, you guys agreed. I mean, this was my own idea, but if you have a contrary view as to my answer, please let me know. So the question is, who should be held liable, the artist or the body corporate? 0% for the artist, 33% for the Maramo, 67% for both parties. I feel both parties should be held liable for using someone else's work without their design and wanting to take credit for it. That's really bold. Now, one disadvantage about copyright in digital age is that it's very easy for anybody to reproduce your work. So you can just see, especially now with NFTs and the metaverse, someone can just take your picture, put it in the digital space, in the virtual reality space, sell it, and then they're considered to be the owner. I mean, those are the issues that arise from IPs in digital era. We had the manual era where it was easy for people to just go and make photocopies. Then we moved into digital stage where it was easy for people to share content through P2P sharing format. Now we've moved to the virtual reality space. NFTs is like the buzzing word right now. Metaverse, same thing, and everyone is like, ooh, I need to do this. So, there are issues when you take a picture of someone. Does the person has a say and knows your creative work and the rest of it? I see this artwork and I like it and I want to put it out there. There's this monkey on face cap, a monkey on a face cap picture that I saw on Twitter, and I really liked it, and I saved it. See, I'm whispering this part. I actually saved it on my phone because I liked it, but that's for like personal use. But then imagine that I take that and put it on OpenSea and decide to sell it. So those are the issues that may arise. So no matter how vigilant or proactive you become, so like when Nigerian artists say, you turn to monitoring spirits. Infringers are always looking for ways, or third parties that don't even own your work are always looking for ways to actually rip off from your intellectual property. They're looking for ways to make money off your intellectual property, which shows that their intentions are not pure. Their dealings are not sincere. So in conclusion, this is the part 1 of the resolving cross-border disputes in the digital era. Part 2 is an interesting case, and it's about the fashion space. I mean, African fashion designers are, doing a lot. I mean, if you enter Instagram, just put hashtag Ankara or ready to wear, you're going to see designs and you will be mind blown. But then there's a thin line between inspiration and copying, which also applies to this case, where someone was inspired and decided to copy and reproduce the work and made money off it. So stay tuned for part 2, guys. I'm going to share more information on how to resolve cross-border dispute. But in closing, the best way to resolve a cross-border dispute is to explore alternative dispute resolution mechanism. I always talk about it because I'm an arbitrator. I'm more of an arbitrator than a litigation lawyer. So that's because of the benefits of alternative dispute resolution, ADR. It saves time, it preserves relationships, it's less expensive. Although other people will have a different view from me, but I believe, and from my experience as well, cost of ADR mechanisms such as arbitration is based off your claim and what the parties are asking for, and I know that arbitrators are always willing to negotiate because they want the parties to actually settle their dispute. So ADR mechanism could be arbitration, mediation, experts valuation, conciliation, negotiation. But in relation to intellectual property, I think the two most used form of ADR is usually mediation, arbitration, depending on the nature of the case. Expert determination may be required. So you can use an ADR mechanism through platforms like the WIPO Arbitration and Mediation Center. The Chartered Institute of Arbitrators also has a mediation and arbitration platform, another ADR institution globally. So just check out within your jurisdiction which ADR institution exists there. If they don't exist, the WIPO Mediation and Arbitration Center is a good place to start. And if you're a lawyer, a law student, a practitioner, just go through their case files to see disputes that have been resolved, IP related disputes that have been resolved through them, software cases, cosmetic cases, a whole lot. And then that's another way to actually build your, if you're looking for IP careers to explore. I have a dream of working for WIPO someday. I hope that works out for me. And WIPO also has a podcast as well, so you guys should check it out. And yeah, if you had a good listen today, if you learned something, please share with your friends and family and contact groups. If you'd like to know more about this case, please send me an email to ipseriesinfo@gmail.com. Until next IP series episode, ciao.